Good afternoon. We'll give everybody a few seconds to join. Hello, and welcome to today's program, Practical ERISA Issues. At this time, I would like to introduce our speakers, Jim Anelli, Andy Hamelski, and Stephen Bowers. Jim is a partner and also the chair of the Labor and Employment Group. He has more than 30 years of experience handling a wide range of labor and employment matters. He focuses his practice on guiding employers in addressing employment benefit matters, defending employment discrimination claims, negotiating executive employment agreements, and advising on related plan design and tax issues for public and private entities. Andy is a partner and the chair of the Life, Health, Disability, and ERISA Group. For more than 20 years, he has been a commercial litigator with experience before state and federal courts and arbitration panels. Andy has helped his clients achieve results by getting to the heart of each case using an aggressive, hands-on, and responsive approach. Stephen is counsel and serves a broad array of corporate clients and has notable experience guiding employers of all types, including private companies, government entities, nonprofits, and educational institutions through industry-specific employee compensation and benefit rules. He advises employers on the design, operation, and regulation of executive compensation agreements and employee pension and healthcare plans. As a reminder, this session is audio only, but we'd love to hear from you. If you have a question for our speakers, please send it through the Q&A tab. If we don't get to your question at the end of the program, we'll be sure to follow up afterward. CLE forms will be sent to you within 1 day of this program. Please listen for a CLE code later in this program, which will be part of the form completion process. And with that, I now pass this over to Steve.
Thank you, Lexi. So I want to give a little bit of an introduction to the presentation overall. The first portion of the presentation is going to deal with a specific issue that is not necessarily a new issue, but it's a constantly developing area, which deals with the ability of medical plans, employer-sponsored medical plans, to engage in subrogation actions to recover some of the benefits they've been paid. But first, most of the people on the call are probably already familiar with this, but I want to give a little background on ERISA. ERISA, the old joke is that it stands for every ridiculous idea since Adam, but it's actually the Employee Retirement Security Act. It is a federal law, so it applies across all 50 states, which governs employee benefit plans, basically dividing them into two types of plans: pension benefits, which are anything that provides for income upon retirement, and then what are termed welfare benefits. Welfare benefits are, generally speaking, health insurance, life insurance, disability, medical and dental, things along those lines. Now, in a lot of ways, the rules are very arcane and were designed around protecting pension plans. And what this means is that the application of those rules, in some cases to the welfare side of the plan, leads to some very odd results. And that's one of the things we're going to talk about. One of the things specifically that results in these odd issues is that there are strict limitations on damages and lawsuits to be brought by impacted parties. Although subrogation provisions are permitted to be placed into a health insurance plan, and I'll give you an example of one later on in the slides, they need to be drafted very broadly and specifically in order to be able for the employer to take advantage of them. If we can move to the next slide, let's see. So a little background now, paring it down into the funding of health benefit plans. An employer-sponsored health benefit plan can be funded in one of three ways. By funded, I just mean simply where the money comes from, where the money to pay benefits comes from. The most common way for smaller employers is through a contract of insurance, where the employer will reach out to an insurer, buy a contract of insurance, and other than the insurance premiums, the employer doesn't really have any exposure against the experience of the insurance plan. Instead, that risk is ceded to the insurer. larger companies and in medium-sized companies in growing numbers instead provide their health insurance via what's called self-funding. And self-funding means that the employer or an entity associated with the employer actually bears the risk. They may pay an insurer to handle the administration of the plan, but the risk is all held at the employer level. It's not ceded to the insurer. And you can basically fund a self-funded plan in one of two ways. You can place assets aside in a trust or VEBA. The trust, that VEBA is a voluntary employee benefits association, which is a form of trust specifically designed for this purpose. And the trust then carries the risk of claims, but the trustee has the responsibility to fund and to preserve the assets in the trust against paying those benefits. Or you can do a true self-funded plan, in which case the risk is the insurance benefits are paid via the general assets of the employer or the plan sponsor. And here, there's a more direct obligation, a direct risk held by the employer, rather than just funding a third-party entity that will eventually pay the claims. The employer actually pays the claims, and therefore there's a higher incentive to recover assets when they're due to be recovered. One of the restrictions that is imposed by ERISA is that ERISA plans can't sue for any claim under ERISA, which ERISA plans tend to sue under, can't be for pure money damages. They can, however, sue to enforce their plan terms. Every ERISA plan is required to be administered according to a plan document, which contains a lot of provisions, a lot of sort of boilerplate language that governs employee benefit plans. But they also have specific terms, which essentially serve as a contract between the plan or the employer as the plan sponsor and the various beneficiaries. To the extent there are terms in the plan that govern that relationship, the plan is permitted to sue to enforce those terms. So I have reproduced here a section of ERISA which deals with the specific limitation on the types of claims that a plan can make. And what it basically does here is that it limits the types of claims that a plan can make to what are termed equitable actions. And equitable actions are things that do not directly result in monetary relief. Instead, they result in the enforcement of a particular right. And that right can ultimately result in monetary relief, but you can't sue directly for monetary relief. How this limitation applies in the context of a subrogation claim has been the subject of multiple Supreme Court cases, and they sort of continually pare down, a little bit of a back and forth, but pare down the manner in which a plan can sue to enforce its rights. And the situation we're talking about here, let me sort of lay the stage. The situation we're talking about here is, for example, a participant in an employee benefit plan, participant in an employee health benefit plan, is involved in a car accident and receives serious injuries. Once that individual has been injured, they go to the hospital, they receive treatment, they get their medical bills, give their insurance card, and the plan, in this case, let's assume it's a self-funded health plan, pays those benefits. Sometime after those benefits have been paid, the employee, the injured individual, goes out and hires a lawyer to sue the individual who hit them, the other party in the accident. Whether through a lawsuit being settled or through a judgment, that individual may receive money that is intended to pay their medical bills. In order to prevent the individual from double dipping, from receiving medical benefits from the plan and medical expenses paid by the tortfeasor here, the plan is entitled to sue, entitled to enforce its subrogation provision to recover the amounts that it has paid that will otherwise be recompensed. Now, the manner in which it sues, because as I said, a plan is not permitted to simply sue for money damages, is extremely limited. And the first Supreme Court case, Great West versus Knudsen, which was nearly 20 years ago, indicated that general money damages, indicate that suing simply for, we paid $10,000 worth of medical claims, give us $10,000, is a legal remedy and therefore is unavailable under ERISA. And this created an extreme limitation on the application of subrogation provisions. However, 4 years later in Sereboff, the court ruled that although a plan is not entitled to sue directly for money damages, they may sue to enforce a subrogation provision. They may sue to enforce the terms of the plan document between the plan sponsor and the employee. And this was further developed in U.S. Airways v. McCutcheon and Montanil versus National Elevator, which limited the manner in which this equitable relief can be sought. If you think about it, there's not really much difference between the situations in Great West and the situations in Sereboff, where Great West said you can't sue for money damages, but Sereboff says you can sue for money damages as long as it's a contract term. So what McCutcheon and Montanil did indicated that the manner in which you seek this money needs to be stringently restricted. And we'll go on to the next slide and I'll describe how. So you can't sue for general reimbursement of expenditures. You can't sue even if you phrase it as a contract action. And the you in this circumstance I'm talking about is the plan. You can't sue for the general reimbursement of your expenditure. Instead, the limitation is essentially that you have to sue for traceable assets, specific money. This $10,000 check has been dispersed to your lawyer. We want that the money that is attributable to that $10,000 check paid back to the plan. And it's even more finely honed than that. If those assets have been dispersed, if the lawyer has paid them out to the plaintiff in the case that we've been describing, then that asset is no longer available. It can't just be traceable to an individual. It needs to be specific traceable assets. So what this means is even if the subrogation provision is very carefully drafted, the plan needs to very carefully prepare to enforce its equitable relief prior to disbursement. And if you're looking at this from the other side, as perhaps an insurer, a motor vehicle insurer, or something along those lines, what it means is if this is not prepared in advance, if you do not receive notice from the plan that they are seeking this type of arrangement, you may have a defense against the subrogation provision. So the plan essentially has a very limited opportunity in which to enforce its terms. I decided to drop a little Latin into the slides here. Essentially, what this means is a plan can't sit on its rights in order to enforce it. It needs to demonstrate a market intent to receive the money. And there are a couple ways it can do this. It can enforce an equitable lien, which is essentially saying that we are giving notice, we, the plan, are giving notice to the counsel in this tort action that we intend to seek reimbursement of X dollars, which represents our medical expenditures in this case. And that lien, if it is imposed before the money comes out, can be enforced via an ERISA action. Similarly, they can impose a constructive trust, which indicates that any assets that are dispersed as pursuant to a settlement or pursuant to a judgment are essentially placed in trust against the eventual subrogation of the plan. Plans have become more aggressive and active in enforcing these clauses. This is in part due to increasing medical expenses. It's in part due to the increased attention in the environment that it's getting from the Supreme Court cases. And it's in part due to the fact that these Supreme Court cases have very narrowly defined the manner in which this type of action can be taken. So a plan will very frequently, and if they are not, they should notify tortfeasors in advance that there is either a lien or a constructive trust on the assets prior to dispersal to the beneficiary. There are frequently fights with the counsel prior to the disbursement because from the tort lawyer's perspective, this is impeding the settlement. However, this type of thing needs to be arranged beforehand. Otherwise, you can have either double recovery or double disbursement from the plan's perspective. In addition, an issue that sometimes arises in these cases is the plan's attempt to establish itself as a personal representative of the insured. And what this means, for example, is that the plan can handle discussions with either the medical providers or the counsel in the tort action with respect to disbursement of medical recovery of medical costs. There are a variety of ways that plans attempt to do this, or that plans can do this. It is very state law dependent, although ERISA is a federal law. It punts to state laws in several areas, including this one, and it needs to be authorized by the terms of the plan. So the problem here is that an insurer can find themselves caught between two competing claims. You've got either both the ERISA plan asserting a trust on the assets that could be dispersed, and the contract holder, in this case the tortfeasor, asserting an insurance claim. So the tortfeasor is saying, you need to pay me these the full benefits against my insurance contract to pay this individual for their medical expenses. And meanwhile, the ERISA plan has come in and said, yeah, but all of those medical benefits have already been paid and you need to reimburse us. So this, where you are a liability insurer, this is where you can have a significant danger of paying the wrong individual before the issue is settled. So what do you do if you're in this situation? Well, first of all, if you are the liability insurer, or if you are the counsel in the case of the car accident, this is highly dependent upon the actual terms of the subrogation provision. So although a plan can assert a right, they need to demonstrate, remember, this is all an equitable principle, this is all enforcement of a contract. They need to demonstrate that the terms of the contract actually authorize this type of action. So you're going to need to review the terms of the plan. Now, a participant in an employee benefit plan is always entitled to receive the document itself. The plan may charge a nominal fee for copying it, but the plan participant, by that very nature, has a right to receive the document. So that would be the way to access the materials. You're going to review the plan document and determine what type of remedy is authorized under the plan. Additionally, there are in equitable actions, there are certain equitable defenses. You can assert that the plan has sat on its rights and therefore hasn't loses the right to it. Or you can assert that the participant has not received a full reimbursement of their expenses, in which case equity would not permit the money to be further reduced. However, taking back away from that, a plan can prohibit those types of equitable defenses within certain limitations. So you want to review the plan terms to determine whether those defenses have been limited. This language needs to be very specific if they're going to eliminate any type of provision. And finally, you want to review any claims of personal representation. And as I said, this is very state law dependent. It's going to be determinative of where the individual is situated, where the accident occurred, but you want to make sure that all of that is done properly. So what I have here on these next two slides is a pretty good example of a subrogation provision. And as you'll see, can you go back and forth between these two slides, Lexi? See, it's pretty substantial. Now, plan documents are not fun reading in general, but this demonstrates exactly how specific and detailed this type of provision needs to be in order to protect the rights of the plan. So it's very important from the plan side that you make sure that these are drafted appropriately to protect your rights. It's very important from the defense side that you review the plan terms appropriately to determine whether the actual actions the plan is taking comport with the contract provision that they are attempting to enforce. So what do you do in this circumstance? Well, the negative result here that you could have from, well, I'll take both sides. From the plan side, the negative result that you have is that you don't get reimbursed for medical expenses that you have already outlaid, despite the fact that these medical expenses were the fault of someone outside your contract action. The negative result from the liability insurer's perspective is a double recovery. So if the plan has properly asserted its rights to be reimbursed these assets, and you as the liability insurer ignore the plan's rights and instead pay out your insured, then you have the possibility that the plan will have the right to sue you for traceable assets, and therefore you could have a double recovery. This is obviously very negative. What you need to do here is have all the parties agree to the distributions beforehand. Now, the plan in some cases the plan's interests in some cases are going to be aligned with the liability insurer because the liability insurer simply wants to get this payment off its books. And if the plan can indicate to the tortfeasor and to the individual who is receiving the settlement or payment, the plaintiff here, that regardless of when they get paid, that those assets are going to come back to the plan, the plan and the liability insurer can assert some pressure on the counsel in the car accident, for our example here. But all of that needs to be handled beforehand. If it's handled after the assets are dispersed, then it's all going to turn on the effectiveness of the equitable lien or constructive trust, in which case that's where the double recovery can come in. If all else fails, it is possible to file what's called an interpleader action, where essentially all the parties go to the court and say, we have money, we don't know whose money it is, you tell us who it is. This is a last ditch scenario, mostly because the terms and the way these things are arranged is pretty well settled currently. But in the event that the parties can't come to an agreement, this is always an option. With that, I will move it on to the second portion of this agreement, but I will turn it over to Lexi first to let everyone know how to get their credit.
Thank you, Steve. The CLE code is 21 Spring 04. Please write this down and make note for your CLE form completion. Again, the code is 21 Spring 04.
Good afternoon. The next part of the program, I'm Jim Anelli, will concern ERISA considerations in M&A deals. And just by way of introduction, your companies may have acquired other companies. You may be a general counsel and have corporate transactions. And one of the things that often comes up in mergers and acquisitions, whether it's a stock transaction or an asset transaction, is employee benefit and ERISA issues. They're often extremely complex, and sometimes they can be quite significant. Some corporate counsel, for example, look to the reps and warranties that are in a typical transaction document, an acquisition document. But it's important to understand when you deal with ERISA, there are concepts of successor liability. And to be frank, some of these issues are extremely thorny. So even having a rep or a warranty in an acquisition document doesn't necessarily mean that that's, that you want to be out there enforcing a violation. An example of that is a situation I had a number of years ago involving a multi-employer pension plan and an acquisition where the client, the general counsel, was looking at acquiring an entity in Massachusetts. And they were pretty close to signing the agreement, and they ran across a multi-employer pension arrangement that they had in part of the company that they were acquiring. And they really didn't know too much about it. And they called me up, and it happened to be the confectioner's multi-employer plan just after Hostess had filed for bankruptcy, and the plan was insolvent to the tune of millions of dollars. And I was talking to the general counsel, and we were going over the impact on going ahead with the transaction if they were to put several hundred employees into this multi-employer plan. And during the course of the discussion, we went through the numbers, and I advised them that if you ever withdrew in the, within the next year or two, in all likelihood, the liability under the multi-employer pension plan would exceed your net worth. So needless to say, that transaction kind of stalled at that point. There are other ways to get around that. We'll talk about that in a minute, but next slide, please. So I'm going to start off with 401k pension plans. It's a very common element of the diligence around just about every company. I'm not going to get into traditional defined benefit plans because, to be frank with you, there are so few of them out there. But 401ks are ubiquitous. Just about every entity has them. And in terms of diligence, there are a number of issues that arise. Part of it could be, have the plans been updated? We get involved in reviews many times where we look at a 401k plan and it simply hasn't been updated in many, many years. So the plan provisions are actually not in conformity with ERISA. And then the question becomes is how to deal with that in the transaction. And typically we can escrow funds, we can have a side agreement. There are a lot of different things that can be done. Have contributions been made? We've often run into plans where contributions haven't been made for years under the plan documents. Have 5500s. A 5500 is a document that a 401k plan files, basically indicating that it's taken all the steps that it needs to take to be in conformity with ERISA requirements and requirements, with the IRS. And for example, they can reflect whether discrimination testing has been done. They can look at whether or not the plan sponsors updated the plan. And we've run into many situations where we have 401k plans and 5500s haven't been filed for a number of years. And so that can be an issue. What about affiliated companies? In a transaction involving several entities, it's important to look at, are there affiliated companies that potentially could be considered to be under common ownership? And how broadly does the diligence review have to be in connection with the company being sold? And that's a really important issue. We can develop reps and warranties around that, but it's really important to take a look at that in a little more in depth. Next slide, please. So what must be done prior to the transaction? Well, the first thing to do is to recognize that the seller in a 401k situation should really be terminating the plan, unless it's a stock deal. The difference between a stock and an asset deal. An asset deal, like it sounds, is simply the purchase of assets by the buyer. Some corporate counsel, believe that, well, you're not assuming any liabilities, but in the ERISA area, that may not be true. In a stock deal, the buyer is simply buying the stock and simply becomes a new owner of the company. The company doesn't go away. So the 401k plan doesn't go away, but in an asset deal, typically the seller will terminate the 401k plan prior to closing for a whole variety of reasons, the least of which is the buyer doesn't want to be saddled with the violations of the 401k plan of the seller. And it can take some time to do this. So it's important to recognize that there are successor liability issues. In fact, one of the biggest issues in the M&A world in connection with ERISA are these successor issues, and we'll talk a little bit about them. Next slide, please. So as mentioned, the simplest, another way to handle this is simply to freeze the 401k plan. That can be done at any time, but there are risks in connection with past violations. To be frank, most companies don't want to freeze. The buyer kind of controls the situation to some degree. They're buying the company, and so typically general counsel will discuss how to handle those plans, and termination is the most common way to do it. Next slide. Additional due diligence items around 401k and pension plans are discrimination testing and top-heavy plans. We see violations in this area all the time with small to medium-sized companies where, for whatever reason, either there was no administrator of the plan, or whatever reason, this company simply didn't track the testing, and there were, or there are significant violations, and typically there are clawbacks. And that's an issue, particularly for many small sellers, that they're simply not aware of, and it becomes a negotiation point. Next slide, please. I said a little bit about multi-employer plans, and I think that this is an area actually that has the greatest risk. And you find it typically in larger transactions where a company is acquiring any number of workers throughout the country, for example. They may have 15 or 20 locations, and several of the locations are unionized. And of those unionized locations, let's say we have the Teamsters, it's a warehouse or something of that nature. We may have multi-employer plans, and a lot of corporate counsel, a lot of general counsel are simply not aware of the rules around multi-employer plans. They're extremely complex. To give you an example, it's not unusual, particularly in underfunded plans, And you can find out if a plan is underfunded. There are websites, that actually report the amount of the underfunding. It's called, for example, if a plan is significantly underfunded, it's essentially deemed to be in critical status. So the Department of Labor reports that information. You can find out that information. But to give you some idea of the severity of this, let's say you've got 10 employees who are in a multi-employer plan. It could easily be the case that your multi-employer liability in connection with withdrawal from the plan in terms of unfunded liabilities could easily be $5 million for just 10 employees. So these are pretty significant issues. So extreme caution should be exercised here. And you can actually find out the amount of the liability simply by asking the fund to do a calculation of liability. Now, there are safe harbors under section 4204 around M&A deals. I will tell you that every time I've been involved in a deal where the seller has attempted to use 4204, the buyers have almost always pushed back on that. The reason is that there are four aspects of the safe harbor to avoid any multi-employer liability, to avoid the withdrawal liability. By the way, withdrawal liability simply means that the employers are changing. In other words, that the employees that are, or the employers that are contributing into the plan would be withdrawing from the plan, will make no further contributions into the multi-employer plan. And based upon that withdrawal, there will be a calculation. And because the numbers of unfunded liability in some of these plans are billions of dollars, even a small fraction of the overall percentage, even 0.5% of several $billion is a very large number. And so that's why these things are pretty significant. But in terms of the safe harbor under section 4204, you can use that to try to get around this issue. And I've seen sellers try to do that. But by and large, what tends to happen, because there's a bond requirement, there's several very onerous requirements on the buyer. And most buyers simply get very concerned when they start seeing the numbers potentially of potential liability if it's not done correctly. And in fact, many transactions where there is a large multi-employer liability, there's a new round of negotiations. And so it's probably a pretty good place to start. If you're looking at acquiring a company that has a lot of union employees, the first place to start is the labor diligence. Unfortunately, a lot of corporate counsel don't get into these labor issues until the very end. And, at that point, a lot has been negotiated. So it's important to turn everything back around and start over sometimes. Next slide. So I talked a little bit about successorship issues. So ERISA has its own successorship rules. However, in the labor area, there's a whole nother set of successorship rules which are different than ERISA issues. So one of the ways that this comes up, if you're just looking at ERISA's successorship rules, are the fact that under the National Labor Relations Act, if you have unions, is an employer under the collective bargaining agreement may be responsible for unpaid contributions to health and welfare plans or contributions into a pension plan. And the successorship rules around the labor area are completely different than ERISA. So it's important to understand if you do have a union environment, partial or complete, for example, you have, say, a location out in Illinois that is 80% unionized and the rest of the company is not. You still need to look at these issues because they are important. And the NLRB sets out the requirements for determining if an employer is a successor or a very clear successor. And there's been a lot of, I could spend another half an hour going over this area, which I won't do. But suffice it to say that in this area, it's extremely important to understand what the successorship rules are, because you may very well be inheriting a collective bargaining agreement if you are a very clear successor that will include extensive contribution requirements to welfare, health, and pension plans. So that's a pretty significant issue. Next slide, please. Misclassification concerns are also another area. It's extremely common right now. In doing the diligence, it's extremely important not just to look at the employees in the company, but to look at the independent contractors in the company. In the technology area, in the transportation area, many companies have substantial numbers of independent contractors. And if they've been misclassified, that means that the employer is obligated for the full regimen of employer benefits, workers' compensation, pension contributions, healthcare benefits, wage and hour concerns. And so it's really a starting point, I would say, if you're in those industries that tend to have literally thousands of independent contractors. You obviously can put in reps and warranties around that. But ultimately, I go back to general counsel and ask them, what level of risk are you willing to assume? If I have a company with, say, 500 or 1,000 independent contractors, this could be a really significant issue. And so either we're going to have a holdback potentially in escrow, or alternatively, the deal may be looked at in a different way. But it's important to look at this and check your reps and warranties, because some reps and warranties actually only talk about employees. No, your reps and warranties need to be far broader than that in this day and age. Next, please. Other issues that are sort of oddball issues are what we call MIWAs. They're multi-employer welfare associations. They're really on their way out. A lot of them went insolvent about a couple decades ago. And so it's not really an issue, but for a company being involved in a MIWA, it's new ground, and highly recommend that you have benefit counsel. ESOPs, if you are buying a company that has ESOPs, you should look at, because typically what happens is the owner will sell the shares, particularly in connection with the generational change in ownership, small to medium-sized companies. And there often may be issues around the liability or the value of the entity. And I think that it would make sense to do diligence in that area to make sure there won't be any future liabilities by your employees suing the company and the former owner. Healthcare benefits, again, under the, that should be under the ACA. There are benefits that need to be provided in healthcare. Some companies, offer those benefits. Some of them do not. And in situations where benefits are not provided, the IRS will come back, in generally several years, 2, 3, 4 years, particularly based on an employee going to the exchange and getting a benefit from the exchange. And there could be very large penalties associated with that. And so it's important to look at, has the company offered healthcare benefits where it is a large employer under the Affordable Care Act. Another liability is failing to reimburse providers under self-insured plans. We talked a little bit about self-insured plans. The plan is responsible for those amounts, and those could be very significant. And companies that have large self-insured plans that are not reimbursing providers correctly, we are often talking about tens of millions of dollars of liability, and those types of claims come up all the time. Consider fiduciary liability insurance if you're concerned about certain issues, post-acquisition, if you or get a tail. I mean, that's another way to do it, is look at it, see if you can get a tail to cover some of these things, or get rep and warranty insurance. But it's difficult sometimes to get that insurance to cover some of these issues. So it's important to look at what type of rep and warranty insurance you're going to obtain. Next slide, please. And at this point, I'm going to turn this back over to Steve, our COBRA expert.
So thanks, Jim. So COBRA is an issue in any kind of merger or acquisition, whether it be a stock or an asset deal. There are very specific regulations that deal where the liability lies, whether it stays with the selling group or shifts over to the buying group. And in most circumstances, this was a very easy analysis because situation happened by operation of law, no need to worry about it. It was a very predictable liability. Problem now is that because of some of the COVID-19 relief, the ability of individuals to elect COBRA has been substantially extended. So it is less predictable what kind of liability could be entailed in taking on an entity that has a COBRA obligation. We can move past this just because we're running short on time. Also want to mention 280G as a major issue in a transaction. 280G is the so-called golden parachute. And what it can result in any kind of transaction payment, any kind of bonus that is paid contingent upon a change in control, usually to employees of the seller, can have substantial tax penalties. And basically, if you look at the second bullet here, and we had a question, are these slides going to be made available to participants? I believe they will be. This second bullet, excess payments, and I'm going to make numbers here, to disqualified individuals that are contingent on a change in control are issues under 280G. There are many ways to address 280G, but as with a lot of things in employee benefits, it's very important to get the manner in which they will be handled addressed very early on in the transaction, because once you've gone down too far down the road, it can be very difficult to address. 409A, rather than give a lot of detail, 409A basically applies to deferred compensation. Any amount that is promised in 1 year and paid in a subsequent year is subject to 409A. It basically requires you to set in stone when it's going to be paid at some point in the future. Move to the next slide. And where this arises frequently in terms of a transaction is in option extensions. So in general, stock options, if you think about it, the whole benefit of a stock option is that you don't set in stone when it gets paid, because the individual can choose to exercise an option when it's most valuable. So options are generally exempt from 409A. However, if they are modified to add a benefit or extended to allow for a longer exercise period in order for an individual to take advantage of the benefits of a change in control, this exemption goes away. And there are potentially massive penalties if this occurs. So this is definitely something to watch, because it's something that option holders generally want to happen, and you've got to sort of convince them that it would be not in their best interest to do so. I'll turn it over to Andy.
Hey, thank you. So this is normally where I make the joke about, lawyers and ERISA lawyers being boring, and I always tie it into some baseball, Yankees in particular, but the way the Yankees are playing this year, I think ERISA may be more interesting. So 2020 and COVID-19, you'd think that the world has stopped, but not ERISA. It was the busiest year actually on record for ERISA cases in the Supreme Court. There's numerous decisions out there affecting plans and different triggers under COBRA and other issues that we will discuss. So moving on to the next slide, just to give you a little outline on where I'm going today. First, I'm going to highlight 3 out of the 4 Supreme Court cases that came down, because I think it's worth talking about them. The 4th is not as applicable to this group, so I'm probably going to, in the interest of time, let that go. Then I'm going to hit a little bit of the hot topics in ERISA litigation. I'm going to then address the procedural issues, standard of review, some arbitration provision issues that seem to cause a circuit split this year. And lastly, I'll talk about some assignments and anti-assignment clauses, which are near and dear to many of our hearts. So looking at these outlines, there are 4 Supreme Court cases. The first one, the Intel case, is really a statute of limitations and a notice type case. I call it the Tolley case, talks about standing to sue. Rutledge is a preemption case, and then it's the Jander case, which I really won't be talking about, where it really goes into a remand in terms of pleading requirements and essentially a stock drop type case. So we won't be talking about that too much. If you have questions separately, I can talk to you about that, but I didn't think it was as applicable for this discussion. Now, looking at the first case is Intel. Here, as most of you know, the most plans I have ever seen have reduced the statute of limitations from 6 years to 3 years, and that's definitely permissible. It's really at this point set in stone that that can happen, and plans are free to do that. What the issue in this case was whether a former employee had technical knowledge or actual knowledge of the change from 6 to 3 years. And this is where, the court affirmed the Ninth Circuit's decision, going out a little bit, I wouldn't call it out on a limb a little bit, by talking about actual knowledge is not the same as just sending your employee the SPD or some announcement of a change. That the court wants to see more than that, that in order to prove actual knowledge, there has to be another step than just sending out that plan. So if you look at the next slide, you'll see, right, if you see, look at actually one more slide, I think is the one I'm looking for. Yep, thank you. That one, the court does take a step back and say, look, the usual ways you can prove knowledge, that's still on the table. And importantly, willful blindness, still on the table. But you can't just drop it in the mail. So the practical takeaway from this is simple. You really need to do a little bit more than dropping it in the mail. You need to have your employees sign that they've received the information, that they've read it, would be great. If it's a former employee, you may have to send several notices. And if they just ignore it, that's the willful blindness. And of course, that would give your counsel enough information to show that they had knowledge or should have had knowledge. They would impute knowledge. So this was a notice case, and I'm going to say this now because you'll hear it about 10 more times. I feel like last year with COVID, notice was the theme. So let's go on to the next case, which is the Tolley case, where here plaintiffs sued because they alleged that the plan was not properly investing their assets and they had a loss of $750 million. Well, the Supreme Court really, in a split decision, said, this is awesome, except for we have an issue, you have no standing. Why? Because the actual plaintiffs were part of a pension, and they were fully paid for their pension that year and years before. So they got their full benefit. So they had basically, in a common sense type reason, had nothing to complain of, and therefore the case was dismissed. So this case, moving to the next slide, you'll see this case used by plans to try to knock out the plaintiffs. So plaintiffs' lawyers need to choose their class a little bit more carefully if they're going to move on, because they need to find someone with a really concrete stake in the lawsuit. So the next case in an 8-0 decision is the Rutledge case, and this is a preemption case, which I found somewhat interesting in the sense that there are now more laws, and this is an Arkansas statute regarding prescription drug costs. And if you look at the next slide, I think you see really the language that everyone needs to pay attention to, which is ERISA is primarily concerned with preempting laws that require providers to structure benefit plans in a particular way. In essence, the court is saying, look, if there's some statute or rule or law that doesn't require the plan to adopt or react to that, is the word I'm using, then it won't be preempted. And the reason that this is going to be an interesting case is that as these prescription drug statutes start to crop up, you're going to see them all crafted in the way that Arkansas did. So you'll see this probably trickle through many different states. If you look at the next section is my hot topics, and Steve already talked about COBRA notices, so I don't want to get too much into it, but this was really one of the most, you don't see a lot of these cases except for this year, where if you look at the next slide, you saw a bunch in Florida, New York, and South Carolina. And these are just simple notice litigation type cases. And the DOL, has issued model notices right on its website, so you can grab those. If you are general counsel or involved in these types of notices, you cannot have that, 4-page single-spaced 5-font notice that literally nobody can read. I like bullet points. I like highlights or italics. You need to give people the dates. So that's the hot topic with COBRA cases, but there are many of them. And if you have any questions, we can talk about them later. Mindful of the time, there were some abuse of discretion standard cases, which everyone, well, I won't say everyone, but essentially a plan has the right to have arbitrary and capricious discretion. And those cases, that was upheld again and again. But what's interesting here, again, is another notice. This is the third time I've mentioned it in this Primera case, where the court said, it's great that you changed the standard of review, but you didn't actually give members the proper notice. And therefore, it's violative of the rules, and we're going to hold you to de novo standard. So that's, again, notice is key. Then if you look at the next slide, there's some interesting cases here, really talking about, in particular, waiver, a delay. I think all of us in ERISA litigation have seen plaintiffs' counsel say, well, we didn't get a decision within the time of ERISA, therefore you've waived everything. And here the Eighth Circuit saying, nope, the delay in deciding an appeal of benefits does not warrant a de novo review. I think this is a case that insurers are going to use over and over again. I know I will for sure. The next case, the Pennsylvania case, really is a choice of law case, but one that talks about de novo, really it's creative on the plaintiff's attempt to try to change the law that the plan should be governed under so that they could get rid of the arbitrary and capricious. It didn't work, but it was creative and I thought worth mentioning. There is, of course, now moving to arbitration quickly because I want to make sure I get through all these. Again, this is another hot topic that we've seen over and over again. And make no really bones about it, plans can definitely have an arbitration clause. There's really no question about that. And courts have really cemented that in. So if you're a plan it's your plan and you want to have arbitration, great. But here's what you have to make sure you're doing. One, again, we're talking about notice. And two, if you look at this Ninth Circuit case, there's an employee contract and the employment contract has arbitration, but the plan doesn't. And every court, in my opinion, is going to look to the plan to govern whether it's arbitrable or not. And this is no surprise the Ninth Circuit found that. Again, if you look at there's a little bit of a circuit split in the Smith case, which I found interesting because the court there said that there's a failure to notify a former employee of the change adding the arbitration clause. So there was a waiver. Again, notice. This is just, the circuit court's not saying you can't have arbitration clauses, but you need to tell everybody. And this is something with former employees, it's just hard to make sure that you're getting to them, and you need to really have a procedure to do that. So we can skip down to the anti-assignment clause. So we can go through those a little bit. So everybody understands, or maybe not everyone, but there's beneficiaries can assign to their medical providers primarily the right to payment. And again, anti-assignment clauses are upheld. However, in some of these cases you can look at that I'm going to cite for you, not all of those anti-assignment clauses have been upheld. In the Third Circuit here, of course it is. And if you look at the next slide, this case in the 11th Circuit I thought was pretty interesting because they found that if you have an assignment, you assign everything, which is the right to seek equitable relief. But in the 6th and the 9th Circuit, they look at it differently. They found that, well, the assignment is really for only the benefits under that plan. You cannot sue for any equitable relief. So we have a little bit of a circuit split here with the 11th, the 6th, and the 9th. And I expect, with the busy ERISA cases going to the Supreme Court, that we could see a Supreme Court decision on this, hopefully in a year or so, to determine what is the scope of that assignment. Does it include equitable relief? If you go to the next slide, I just noted here, interesting about how, generally speaking, again, in the Third Circuit, these clauses are permissible and enforceable, and you're seeing more and more of them. But in this Beverly Oaks case in the Ninth Circuit, and you probably noticed them, keep saying Ninth Circuit because the Ninth Circuit just loves ERISA cases. And I think if you look at most of the Supreme Court cases, they're always out of the Ninth or really the 11th Circuit. But here, this was something that, again, it's a notice type discussion. We have to be careful with what we say when we speak with providers. So here, the insurer was equitably stopped from raising the anti-assignment clause because the insurer promised that the actual provider would receive payment. And this concerns me to the extent that sometimes insurers have these form letters that go out. And if the form letter goes out with the improper wording, you could be really waiving your right to invoke your anti-assignment clause. The Cell Science case, which is a Fifth Circuit case, said the opposite. So again, another split, but really looked at the record to see if there was a misrepresentation or whether the provider was misled. And there they found no, that did not occur. But again, our communication with providers need to be clear. And if you're an insurer, you really want to make sure that your form letters don't waive your anti-assignment. I ended with about 4 minutes for questions if anybody has them. But I'm going to give you a takeaway, which is, 2020 COVID, lots of interesting cases, but many of them are really flowing from notices and making sure your notices are timely, making sure that they're clear, that they can be understood by a reasonable plan participant and the reasonable person standard, and that you need to make sure that you're not waiving any of your provisions by using loose or unclear language, because courts seem to be jumping on waiver and estoppel issues all over the place. So again, be careful with what you say.
Thank you, Andy. On behalf of White & Williams, we want to thank you for joining us today. If you have any further questions, please reach out directly to any of our panelists. Their contact information is available on the presentation slide right now and will be in our follow-up email. As a reminder, CLE forms will be sent to you within 1 day of this program. Thank you again for joining and have a wonderful day.
Thank you, everyone. Thanks for attending. Have a great day.
Thank you, everyone. Any questions, feel free to give me a call, email me. Happy to discuss anything in depth a little further.
Thank you, everyone.